Hey everyone, today we're going to talk about an important topic that affects many business owners and directors in Singapore: personal guarantees. Whether you're a director or a business owner, understanding personal guarantees could help you make smart decisions when signing contracts. So, what is a personal guarantee? A personal guarantee is essentially a promise made by an individual, most frequently a director or shareholder of a company, to be personally responsible for the debts or the obligations of the company. This means that if the company defaults on a loan or fails to fulfill a contract, the guarantor becomes personally liable to cover those debts. Personal guarantees are required when a company, usually a private limited entity, enters into significant contracts or loans. Because the company is considered a separate legal entity, its shareholders and directors are generally not liable for its debts or obligations. This creates a level of protection for the directors and shareholders, but no protection for the creditors or other parties involved in the contract. So why are personal guarantees so common? Well, the primary reason is to protect creditors and parties to a contract with a company. When a company enters into a contract, the other party, it could be a bank, a supplier, an investor, the other party takes on some risk with the company. Because if the company goes bust, then the directors and shareholders are not liable for the company's debts or obligations. Also, since the company is a separate legal entity, these parties to the contract, whether banks, suppliers, or investors, may not be able to recover the debts, if things go wrong. This is especially so if the company does not own any significant assets such as offices, property, machinery, or inventory to seize and auction off. Perhaps the company is in financial difficulty and only has a few $1,000s in the company bank account. Therefore, to mitigate the risk of non-payment by the company or default, the other party to the contract often asks the directors or shareholders of the company for a personal guarantee. This ensures that even if the company doesn't have enough assets to pay off its debts or obligations, the other party can go after the guarantor's personal assets, like their house or personal savings. Yes, it's that serious. Now, let's talk a bit more about private limited companies in Singapore. As I mentioned earlier, private limited companies are their own legal entities. This is a good thing for shareholders because it limits their liability to the amount that they invested in the company. If the company fails, they lose only what they put in, but nothing more. If a company goes into liquidation, for example, creditors may end up recovering very little or nothing at all. This is why when private limited companies engage in high-stakes transactions such as loans or contracts with big financial commitments, the other party will want personal guarantees to make sure that someone in the company is held personally responsible for the debts or obligations. Now, the million-dollar question: should you, as a director, sign a personal guarantee? It's tempting to want to move the deal forward, and sometimes personal guarantees may feel like a minor formality. But be very careful. Signing a personal guarantee can have serious financial implications. If the company defaults, you could end up paying off the debts of the company with your own personal assets. That's right. Even if the company goes bankrupt, you are still responsible for the company's debts. Therefore, before you sign a personal guarantee, always consider your financial position and whether you're willing to take on this risk. One approach is to negotiate the terms of the guarantee. For instance, you could request that the guarantee only cover a specific period or limit the amount you are personally liable for. It's also worth considering asking for joint guarantees if you have other directors, so that the responsibility is shared among several people. Now, let's discuss whether it is wise for a director to sign a personal guarantee. It really depends. If your company has a strong financial outlook and the risk of default is minimal, signing a personal guarantee might seem like a reasonable decision. But you need to be fully aware of the potential risks. If the company fails, it's your personal finances at stake. Ultimately, the best advice is to seek legal counsel before signing any personal guarantee. A lawyer can help you understand the specific terms and the risks involved, and may even help you negotiate a better deal. It's always better to be safe than sorry. So there you have it, an overview of personal guarantees, why they are used, and whether or not it's wise to sign one. Remember, when it comes to your own personal assets, Always be cautious and get legal advice before making any commitments. If you have found this video helpful, don't forget to like, share, and subscribe for more legal insights. Thank you for watching.